But that sort of brings us to our main topic, which is what is happening in the land of the lawyers. And we wanted to talk today about the two sides of the ethics coin. So ever since ChatGPT emerged on the scene and poor Steven Schwartz cited those hallucinated cases in the brief he filed with federal court, almost all of the conversation around ethics has been focused on the ethical risks involved in using AI and hallucinations and biases. But we're starting to see data, and we talked about it on a recent podcast with the VALS benchmarking study, that AI are increasingly as accurate as we are at producing new content. And now today we were going to talk about whether we're going to start to see a shift in the conversation about ethics towards a world where it will soon become unethical not to understand how to integrate these tools into your day-to-day practice. And we have two examples of case studies where the headlines might lead you to believe that AI was really like the transformative piece of the litigation involved in both of these cases. On a closer read, it's probably a little bit more mundane than that, but I think still important for people to be paying attention to. So maybe I could turn to you, Bridget, and ask you to guide us through the 2 different cases that have come out with some AI influence in their lawyering.
Yeah, I mean, what's interesting about both is that they both were the AI had a place in the headline about each of these cases. One, they're both med mal cases,
And both in
and
Georgia, which is
and both in
interesting.
Georgia, personal injury practices in Georgia. One where there was a $25 million verdict, and one there was a $7.2 million verdict. And I don't really think that the particular med mal underlying issue is what was most important about them. That the headline, in each case, it was like AI, wins a $25 million verdict, which isn't exactly what happened. And maybe I'm exaggerating the headline, but I think it overstated like the role of AI in each of them. On the other hand, in each case, the use cases, the way the lawyers use them were were the ways I think a lot of people are using them just in regular, everyday life. They were not for, researching or presenting like AI written documents to a court, which seems to be where everybody's got the most um, concerns, but rather in helping them present their case. So in the $25 million case, the lawyer used ChatGPT to help her think about how to talk about the particular injury to a jury. And it was like many med mal cases, there's a sad story. And how you talk about that particular sad story to a group of 12 people who are not lawyers, but are having to make some legal judgments that are around facts, is the kind of thing that, frankly, the technology would be great at. Like, I'm not surprised at all that she was able to get good help from the technology to think about how to talk about the underlying injury in that case. And in the other case, the lawyer used ChatGPT again to help prepare for the expert testimony on the other side. I believe he said they even were able to find, a paper where one of the experts on the other side had, said not X when he was testifying to X. They literally found, like a smoking gun statement by an expert that they would never have found on their own. And, you and I know from like the work that deep research does that no matter how good we are at legal research or Google research or any other kind of research, um, we're no match for what the capabilities are that this technology has now. So that too feels like a very like yes, for sure. Like, why would you not try that? You would do all the things you normally do, I think, but then why wouldn't you um get some help with thinking through the expert testimony you're going to be facing, especially since you have their reports, right? And you can go figure out in advance like what else is out there that you might want to ask about in a really targeted way. Um, so in neither case was there anything about the use of the technology that I think would cause anyone to say, "Oh, no, there's, like, an ethical concern in using it." And I think to your point, it's probably the opposite. Like, once you know that it can help you present a better closing argument, especially around, a tricky or sticky, set of facts, to talk about to people, or once you know that you can get help, figuring out how to counter an expert, that is, at the end of the day, what the whole case is about in a med-mal case. Um, isn't it unethical to not use the technology that, is available to you? It is so interesting. I mean, I was doing a prep session earlier today for a presentation I'm doing in June to a group of lawyers in a practice area where they're really, really late to the party, but they're trying to figure this out. Like, what does it mean for our practice area? And the folks organizing the conference, like, kept focusing on, like, we need to know all the ethical problems and all the ethical risks and I was thinking, like, well, I mean, I'm gonna probably sell you on both sides of that. Like, yes, you wanna be really careful about what you do with any confidential information. I think we all know that lesson now. And you wanna check the technology's work because it's gonna give you an answer even when it's, like, not sure. But you might have to use it, to provide competent representation once the technology can do things that you simply can't do as well. Um, I don't know. What did I miss there in the 2 cases?
Nothing. I mean, I think too, I think our shared worldview on the legal profession writ large is that we're not client centered enough, not public centered enough, and we're very lawyer and judge centric. And I think if you were to ask the average person paying her lawyer to represent her in a case, like, this powerful technology exists, we could use it or not. Um, you know, would you like us to use it with safety guardrails in place? Like, I don't know many people who would say no. I think it's good, that the ABA guidance came out and there's discussion about having informed consent with your clients, but to me, that's the whole ballgame. That's why you're there, and I think the $7.2 million verdict case to me stood out as just, you're representing people and you're seeing this tiny little piece of the ocean through discovery and through your research that you're able to do, but there's just these depths of data and information that you haven't had access to, or new ways of thinking about things or sharing things like the $25 million verdict. And I don't know why you wouldn't wanna plumb the depths of the ocean and find all of these different things that are like unlocks for lawyers. So I too have been trying to have a more nuanced conversation. And actually, like, I have found that it really perks up lawyers' ears when they hear that part of it because they're not hearing that part of the story about all the things they could be doing.
I feel like we had this one, sort of counter argument to, all of the risks, all the ethical risks, which was fees, which even the ABA formal opinion, flagged for lawyers. And we've heard from, in-house counsel, right, that say if you can do the work with the help of this technology at, a fraction of the cost, there is an ethical rule that says you have to do that. And that I feel like people have had their heads around, or lawyers have had their heads around now for some time, which has been the primary reason why I think lawyers are like, "I guess I'm gonna have to figure it out," right? Like, I'm gonna have a duty to, an ethical duty to for cost reasons, but also, just to be competitive in my market. If my neighbor's figuring it out and can offer the same services significantly cheaper, if I wanna continue to compete, I'm gonna have to use it. But this is like just an extra layer to that. It's not only that you can do it and save money, but that's true here as well, but it's you can do it better. Like, that's the difference, right? When I used to do jury trials, either before I was on the faculty and or at even when I was working with clinic students, I hardly ever had clients who had, like, significant resources for any of that litigation. Sometimes in our post-conviction innocence clinic litigation, we were able to recruit volunteer experts, but it was always volunteer experts. There's a tremendous upside for lawyers who are working on really important cases but don't have big budgets, whether they're at small firms, in solo practice, in, post-conviction innocence clinic practices where they really don't have the kinds of budgets for experts or to counter experts that traditionally you needed. I'm not sure you do anymore. So it's really, I think that's a huge benefit to the legal profession generally.
Same, and we've been saying from the beginning, I thought it was fun that these were 2 plaintiffs' lawyers, who benefited from this, not that they were enormous firms on the other side in these 2 specific cases, but you can see how going up against a behemoth firm, if you're able to source some of that research or shape your closing argument in a way that you wouldn't have otherwise, it just gives you such a leg up. And so I'm like just constantly on the hunt now for stories like this to share with lawyers. I think it really makes concrete what we've been trying to say in a very theoretical way. And I hope more lawyers start to think about these tools as augmenters of their abilities.
Yeah, you just gave me an idea. It is actually these 2 specific examples are so great because they are concrete and lawyers will be able to relate to them right away, right? We always hear when we present to lawyers like, "Okay, I get it. It's definitely a disruptive technology, but what do I do with it? Like how do I really do something with what I've heard today?" And I like having these 2 examples.
Thank you for tuning in to 2030 Vision AI and the Future of Law. If you enjoyed this episode, please subscribe to our podcast and leave a review. Stay informed and inspired as we continue to explore the AI driven future of the legal profession. We'll see you next time.